Okay, please listen. And from the questions, whatever I asked you now, even before I start the recording, so many questions I asked you. And 95%, I'm very happy that everyone remembered the concepts. Both the batches, whether you or Coimbatore, everything. Really very much simply because in the classroom, students may not remember so many things, but at least you are trying your best attempt to remember all the concepts. Main important points I asked, I got a correct answers for all the important answers. So if you read like this, you will definitely get that 70 plus in law, provided you read all the chapters like that. Share capital chapter will come only for 12-15 marks. Like that, every chapter you have to read. If you read, definitely you will get. Sir, okay. Now listen. Let us now complete a concept called as a transfer and transmission. The name of the concept is transfer and transmission. 4 sections are set. 56, 57, 58 and 59. Rarely comes in exam, but there in the syllabus, there in the bare act, we have to read. Very, very rare. In 6-7 attempts, one question also will not come. But still, there in the syllabus, we have to read. What are the 4 topics? Can you please tell me? 56, 57, 58, 59. 4 sections. We will read in the sequence of 56, 58, 59 and then 57. Listening? 56, 58, 59 and last we will come to 57. That's the right sequence to read. Okay. 56. Please come over there. Transfer and transmission of securities. First I will explain the base logic of this chapter, I mean this topic. After that you can read. See here. Shareholding can be of 2 types. Physical holding, electronic shareholding. First one, physical shareholding, electronic shareholding. When the shares are held in electronic form, when the shares are held in electronic form, you will be the beneficial owner, depository will be registered owner. It is as simple as holding money in a bank account. Holding money in a... I will ask one question, you first answer this. Money deposited by you in a bank account. You deposited money in the bank account. Listen carefully, sir. You deposited money in a bank account. Your money belongs to you or your money belongs to the bank? Did you understand my point? Yes, for money, who is the registered owner? Sir, I got a money payment. Case Academy made 10 lakhs payment to me. Listen to the concept here. Why you are questioning me? Listen. Case Academy paid me 10 lakh rupees. Okay? Now tell me that 10 lakh rupees comes and sit in my bank account or not? Yes, sir. Now answer my question. When they make the payment, the 10 lakhs will be credited to bank. Now I want one question. Money coming into my bank account is belonging to me or it belongs to the bank? Belongs to you. Answer here. Belongs to the holder of the bank account or to the bank? Bank. This is what you need to understand. Then negotiable instruments, that is a logic, na? The basic catch of the main banking system in India is banks are registered owners for your money. You are just a beneficial owner. Sorry. If you don't believe this point, I will ask you a question. Just it require a basic. So listen carefully. Whether if any is there or not, let us check. Tell me, you made a FD. You made FD. 10 lakhs FD you made. It's a deposit of money or not? Yes, sir. Tell me now. Once you made an FD, Money belongs to you or to the bank? Your money, I'm not denying that. Your money only. But in whose hands it is now? Who will use your money? Who is registered owner now? The interest only will come to you. You are the beneficial owner. For all that bank deposits, we are all beneficial owners only. What do you mean by beneficial owner? Whenever you want benefit out of it, I will provide you. Go to ATM center, put your card, swipe it. Benefit I will give you. Every 3 months, interest benefit will come, I will pay you. But it is our money. We will use for whatever purpose we want. Are you understanding or not? Yes, use common sense again. You went to a ATM machine. I said this example, right? Yes, sir. For you only I said? Yes, sir. If you deposit money in ATM machine, if you are a registered owner, you should get back the same cash when you withdraw. Yes, sir. Are you understanding the point or not? Yes, sir. Sir, I will give one example. I gave car at a parking. Okay? After 3 hours I came back. After 3 hours I came back. He will give another car. No. Sir, car is a car, sir. You want car benefit, you take whatever you want. Or I want only my car. No. Because car is registered in your name. Did you understand the point or not? Yes, sir. You are a beneficial owner of the car, a registered owner. Yes, registered owner. That's why car has a registration. House has registration. Cash don't have registration. Share has registration, but that registration is done in the name of depository. Cash registered in the name of banks. Shares registered in the name of depository. Who is the registered owner? Depository. In a cash, who is the registered owner? Banks are registered. Clear or not, everyone? Yes, sir. So therefore, try to understand. We have a wrong impression on banking system. First of all, we don't know how banking system operates. Therefore, you get lot of doubts on that. But the catch point is, banks will hold cash as a registered owner. That's why they can use for whatever purpose they want. In my account, 10 lakhs cash is there. Savings account. Example. How much? 10 lakhs. Now tell me, when I go to ATM center, when I put my debit card, swipe for 10,000, they will give 10,000. Because I am authorized for a benefit of 10,000. Yes, sir. Listening? Yes, sir. But my 10,000 remaining 9,90,000 is there, na? That will be put into circulation already. Listening? Yes, sir. Sir, common sense you use. If bank does not use your money, why it will pay interest to you? Bank paying you interest means it is using your money or not using? Using. How it can use it if it is your money? Will parking person use your car if you keep there? No. We will kill him. Yes, sir. Listening? Yes, sir. Then why parking la why the person will not use? Why bank will use? Because between you and the bank, the relationship that exists is a registered owner and beneficial owner relation. In a car parking, it is a relation between a bailor and bailee. There is a lot of difference. Are you understanding or not? It's a relation of a bailor and bailee there. Here, registered owner, beneficial owner relation is there. Registered owner has the rights to use the asset. Beneficial owner is entitled for the benefits out of it. Listening? Yes, sir. That much difference is there between bank and customer and laundry and the person who give clothes on laundry. If you give cloth on laundry, what will happen? Your clothes he will take. Goods transferred from one person to another person. It went for a purpose. After purpose is accomplished, you should give it back, either in the same way or in the altered manner. That's all. That's a bailment contractor. There is no person who does laundry is a registered owner. So Shaktik registration will be there. It is registered in my name. Over action. Shaktik registration in registration will not be there for everything, but certain things will have registration. Listening or not, everyone? Yes, sir. So tell me, bank is whom? The customers are beneficial owner. Customers are beneficial owner. They will give me checkbook. I issued 4 lakh check. Bank. Now the bank work is, in order to provide me the benefit of the transfer, provide me the benefit of transfer. But I deposited 10 lakh cash in my bank account. Once I put 10 lakh in my bank account, bank will not use my 10 lakhs, it will put into circulation. Answer here. Do you know what happens actually? We do bank audits. During bank audit time, we have 1 day given for chest verification. Bank chest will be there, currency chest. Strong room they call. Chest verification will be there, bank chest verification. Okay, like this room will be there. 2 police personnel will come along with us, protection sake. Okay, gunman protection, you can understand. Inside what is there? Cats and dogs. Cash is there. Anything can happen, money can do anything. Therefore, 2 persons will come along with us inside the strong room. We will go inside. Sample basis, we will check the lockers. Not all. If we get big branch, it will be around 8,000 crores, 9,000 crores. Physical cash will be there. Who will verify all those things? Sample verification will be done. Okay? Sir, we will do sample verification. What will happen, do you know ideally? For example, Koushik Mukhesh came to bank, deposited 10 lakh rupee cash. Listening? Yes, CDM la maximum how much? 60,000, 1 lakh or 2 lakh you can deposit. But 10 lakh or 15 lakh cash you can't deposit like that. Bank loan you have to deposit that. We will come to the bank. We will deposit that money. Where it will go? It will go to the currency chest. 7 days in 1 day in every 1 week or 2 days in every 1 week, like that people will come and they will refill that ATM center. Listening? Yes, now listen to the drama now. Koushik Mukhesh brought a cash worth 5 lakh, 100 notes. I went to the bank. I deposited 5 lakh cash bag. Bank has taken my 5 lakh. I went out. My bag containing 100 rupee notes was given to the ATM center person. He will directly take and dump it into the ATM. Now you should not tell, my cash completely given to public. Your cash I am not giving. It is our cash. How then this is my cash I deposited. The moment you deposited, you became a beneficial owner. If you want withdrawal, you do the withdrawal. Benefit of withdrawal we will give you. If you want to use it, that benefit of usage we will give you. If you want interest, keep it with us. 3 months after we will pay interest on that. But it is registered with us. Once it comes into the bank, bank becomes which owner? Who will become the beneficiary? No problem, take it easy. Bank becomes which owner? Next, the customer will become which owner? That's all. This is the idea behind this. Understood the logic clearly? So after so long time we understood one Jivita Satyam. The point is, bank is always dash. Customers are always what? Depositories are always what? Clients or customers are always what? So remember this point first. Who is registered? Who is beneficial is important for us to understand this chapter. Clear? Yes, now please tell me, shareholding can be in 2 ways. Number 1, physical. Number 2, electronic. If you hold in electronic form, whose name it will be registered? Depository. Then who is the beneficial owner? Shareholder will be the beneficial owner. Listening or not, everyone? Yes, sir. Money transferred from one phone pay account to another phone pay account. Electronic transfer or physical transfer? Electronic or physical? Electronic. Very good. Electronic transfer will be made. Correct? Yes, from this, the moral of the story number 1. Whenever electronic transfer is made, identity of that particular instrument is lost. I told you, numbering of shares. Numbering will be there when it is a physical document or electronic document. Electronic document will have numbering or no numbering? No numbering. Clear, everyone? This is the first one that we need to understand. Now, section number 56, 57, 58, 59 are talking not about electronic shares, talking about the physical shares. First logic that everyone has to understand. 56, 57, 58, 59 talking about dash. Physical shares are electronic shares are physical shares. For electronic shares, you are the beneficial owner or registered owner? Answer. That's all. You are not the registered owner. The question of transfer, all these things you will not do. Transfer will be done directly from one depository to another depository. You are not personally involved in that. Therefore, the question of transfer, transmission from your side will not get attracted. Yes, are you listening, everyone? Yes, sir. I will give you one diagram. If you understand the diagram properly, just in 35 to 40 minutes we will complete the chapter. Transfer area. Very easy. But once you understand the chart. Shall we? See the screen once. You can write it later if you want. But please listen first. You tell me, I will write it. For having a sale of share to happen, how many parties are involved? To sell shares, how many parties are involved? Means why you are getting doubt here? To torture me, 2 parties are involved. Number 1, buyer. Number 2, seller. I am not asking about brokers. Don't do overaction. Brokers will do the transaction, they will facilitate. That who asked about that? I am asking who are involved in the sale transaction. Tell me now, how many persons are involved? See the screen. On D0, there is a transferor. There is a transferee. Transferor transferred shares to the transferee. One diagram, la full chapter I will include. Listen carefully. Tell me, what happened? On what date? On what date? Who sold? To whom? What he has done? Shares are sold. Shares are sold. Don't use the words in whatever way you want. Don't tell that he transferred. He didn't transfer. He sold. That's all. Transfer has to be executed. Okay. I will ask a question first. Answer this. This building belongs to this fellow. Suraj, your name? Yes. Say example, don't shout now please. This building belongs to Suraj, owner. I wanted to buy this building. I gave him 5 crore worth check. He took it. Listening? Yes, sir. Now, this particular building worth amount I paid him, so I will become the owner and he will not be the owner. Correct? Yes, no, still he is only owner in the records of the government. Transfer not yet happened, sale happened. What happened? Sale happened. What happened? Sale happened. Common sense shall we apply once again? Yes, shall we apply common sense once again? Yes, answer no? When you buy the car, permanent registration will come immediately after some time. RTO has to register in your name. It has to transfer the ownership. Yes, that's all. You bought, they sold, sale over, transfer not yet over. Clarity, yeah, everyone? Yes, sir. Whenever I call transfer, means what? Registration should be transferred. Listening or not? Yes, sir. What should be completed? What should be completed? When you hold shares in a depository, registration will be done by the transfer or transferee. Correct? Yes, who is the registered owner in case of electronic shares? Therefore, they will do that work. You will not do. That's what I am trying to explain. Yes, electronic shares la you are whom? Who is the registered owner? Registration and all these things should be done by whom? Registered owner. Who is the registered owner? Therefore, one depository and another depository will do all those works. You need not do all those. Yes, listening? Yes, you buy the shares in Zerodha app. You sell the shares in Zerodha app. You will apply for registration. You will apply for registration. Who will do all that work? Back and the depositors are doing. That's the greatness of Depositories Act. Or else, how much registration expenses, how much laborious work used to be there once upon a time? Listening? Yes, sir. That act has changed the way in which India's stock markets are working. Depositories, if you remove from the stock markets and see, Now what is the transaction settlement time? T or T plus 1 or T plus 2? It is T plus 1. Feb 22nd, Feb 25th, 2022 onwards, SEBI started implementing T plus 1. From when? 25th February 2020. I told you na stock market session is there. I told you that we are having one stock market session in KS Academy. I told you people also, right? August it will come as an announcement. There we are covering everything. Settlement dates, the people don't have a clarity when the trading is getting settled. Settlement once upon a time is T plus 2. Do you know? 2006-7 time settlement time is T plus 30. Reduced to T plus 25 in 2007-8-9 time. Listening? 2011 mandatory dematerialization came. Phased wise implementation. It was reduced to T plus 10. 2019 time ki T plus 2, T plus 3 it is. 2021 time it became T plus 2. 2022 February 25th onwards it was made as a T plus 1. India is the only country to settle in T plus 1. Not even USA. USA is also settling in T plus 2. India is the only country in the entire planet which is settling its stock transactions in one day. Means demat accounts or depositories are working like that in India. Listening? Yes, sir. Last one question I will ask, answer, then I will write the remaining part. You purchased a house. You purchase house. Okay, you are a buyer. There is a seller. Yes, both of these people should go to registration office. Yes, they have to give their thumb impression. Yes, they have to sign on the documents. Yes, 2 witnesses are required to register the property. Yes, this is what generally happen. Without involvement of buyer, seller, person, witness, nothing is required. Online we will do. One day it will be completed or not. Yes, that's how the share registrations are done in India. You are not even involved in that. Listening? Yes, sir, without my involvement, how dare depository can do all these nonsense, sir? A question may arise or not? When you are opening demat account, they will get it signed with you. You will click agree. In that agree, one of the agree is you are agreeing depository to do registration work on your behalf. Sir, I will disagree. Demat account don't open. I will not open, sir. Then you will not buy share. As simple as that. So you are forced to agree that. That's why we will click on agree. All terms and conditions agree. And no fraud here. Depositories are genuinely working in India. Sir, okay. Main concept. See the screen. Answer. Fatafat. Complete. Who is buying? Huh? Who is selling? Selling what? To whom? Sale happened or transfer happened? Sale happened. Transfer of shares not yet happened. Okay. Credit sale, do you know? What is credit sale? Goods came, but money not yet paid. Do you know advance payment for sale? What is that? Money paid, goods not yet come. This is like that. Money paid, not yet, goods not yet received. Sale happened. Okay, money happened. D0, this is what happened here. Now, these two people will take one form called as SH4, called as instrument of transfer. Everyone repeat. Instrument of transfer, also called as STD. Share transfer deed. Full form? What is the form number? What is that known as? Instrument of transfer or share transfer deed. Which date all these things are happening? D0. Listening? This share transfer deed must be having, it should be dated, it should be signed, it should be stamped. What do you mean by stamped? What should be stamped? Seal will be there, na? That seal should be there. Like this you should not think. postal stamp will be there, na? That stamp should be pasted on that. Like this also you should not think. I know how you will think stamp. We know 3 stamps in India. Number 1 stamp, number 2 stamp, number 3 stamp paper. This is stamp paper. Listening, huh? What is this SH4 called as? Ayya, meeku namaskaram. Please answer properly. What is SH4? Another name. Deed can't be written on white papers in India. You are living in which country? India. So be like an Indian. In India, white papers like deeds are not valid. You should write any deed only on a stamp paper. That's called as stamped. Stamped does not mean stamping. Okay? Done. So now everyone explain the transaction on D0. What happened? Transfer or sold shares to transferee and executed SH4 called as instrument of transfer or a share transfer deed. It should be dated, signed and stamped. For this, transferee will pay consideration. What it will pay? Consideration he will pay. Up to here clear or not, everyone? Yes, sir. Now listen. 60 days means D60, last date for sending instrument of transfer to the company for registration. For what? Registration. Tell me, what is the time limit within which we are given to send the SH4 to the company? 60 days. 60 days from the date of execution. 60 days from the date of execution means what? Signing. On what date you sign? You will, sir, whenever we sign, we write the date below or not? From there 60 days will be counted. Within 60 days you should submit to whom? You should submit to whom? Company. For what? We are talking about listed companies or unlisted? Unlisted. If it is a listed company, shares are held in physical or dematerialized form. When it is dematerialized form, depositories are not the company. That means which company we are talking about? Unlisted. Either a private company or unlisted public companies we are talking about. Clear, everyone? Yes, sir. Within how many days we need to send? 60 days. Within how many days? 60 days. Now listen carefully. The moment company receives that particular, the moment company receives your share transfer deed, it will start processing the registration work. Which work it will start? Registration work. Registration work will take some time. Okay, wow? Registration will take some time. It can't be completed just like that. Okay? Now listen, time limits, everything I will tell later. Main point is, last date for sending the IoT to the company for registration will be D60, 6 days from the date of execution. It takes some time. Finally, on a particular date, the shares are registered in the name of transferee. So finally it will be registered in the name of transferee. Now the question arises. Say example, say it happened on D100. Say example. Okay. You have to send within 60 days. And it may take some number of days. 100th day, they said that we are registering the shares in your name. Okay. To be very much perfect, let us change the date also. Let's say it is 80. D80, shares are registered in the name of transferee. Now the question arises, From 81st day, who is the registered owner? Transferor or transferee? 2 days before, who is the registered owner? Transferor is the true owner of that particular shares. Correct, everyone? This is the basic idea behind the transfer concept. Up to here, everyone understood clearly? This timeline chart is not yet complete. Still some concepts are there. First, let us read the BERAC before we move on to the next one. Please come to section number 56. Okay. So please show some importance to the topic. Let us complete all the 4 sections first. Okay. See the screen. A company shall not register a transfer of securities of the company or interest of a member in the company in case of company having no share capital other than the transfer between persons both of whose names are entered as the holders of beneficial interest in the records of the depository, unless a proper instrument of transfer in such a form as may be prescribed. What is the form? SH4 is duly stamped, dated and executed by or on behalf of the transferor and transferee, and by specifying the names, addresses and occupation if any of the transferee has been delivered to the company by the transferor or transferee within a period of 60 days from the date of execution, along with the certificate relating to the securities, or if no certificate is in existence, along with the letter of allotment of securities. Stop there. Take a minute time, read it first. Okay. Have you read subsection 1? Now listen carefully. One by one, let us break the points and read. This is applicable for a company. Public or private or both? Write down. Public and private. Shall not register a transfer. Stop there. Who is registering the transfer? Alright, did you read? Read. A company shall not register the transfer. Okay, company shall not register the transfer of securities of a company or interest of any member other than so and so, unless means what? Conditions. Some conditions are given. Okay. Before even going into that, listen to one important point. Who will register? Everyone. Who will register? But not the depository. Why depository is not involved? Depository will not come when the shares are held in physical form. When depository will come? Now the shares are held in physical form, electronic form, physical form. Why depository will involve? Company only will do registration work. Who will do registration work? Who will? That's the point. So company only will do the registration work. That's why other than between the persons whose names are entered into the holders are beneficial interest in the records of the depository, means this section will applicable in a case other than demat holding. So this section will apply for demat holding or will not apply? Will not apply. First with that mindset you have to read. Shall we continue? One by one, please answer. Section applicable to which company? Both public as well as private. Next one. Shall not register the transfer of securities of the company or other interest of a company having no share capital other than the holders in the records of the depository, unless, actually from here it is important for exam, proper instrument of transfer has been duly stamped, dated and executed. First tell me, in the chart I have already written that point or not? Yes, it should be dated, it should be signed and it should be stamped. Next. Delivered to the company by the transferor or transferee within a period of how many days? 60 days. 60 days from what date? Date of execution. Tell me, one second, I didn't write that point here, but I will write for your clarity's sake. Tell me, who will send the share transfer deed? Who will send the share transfer deed? Transferor or transferee can submit it to what? Company. For the what purposes? Registration purposes. Who can submit? Transferor can submit, or even? Now tell me, I am transferring the shares. What is the guarantee that really these shares are belonging to the transferor? Attach share certificate. Attach a share certificate. What is a share certificate? It is a acknowledgement, proof that you hold some number of shares in a company. That proof will be established using a certificate called as what certificate? Share certificate. That's all. Over. Please read subsection number 1 first. Interest of the, in case of company not having share capital, he will not have shares, but he will give guarantee. In that case, guarantee will be treated as a interest. Interest means not interest payment. Interest means the concern that he has on the company. Okay. Company not having share capital, we will discuss in a different chapter. There I can explain much better about it. But since you asked the question, I am telling you, here he used the word interest of a member. He didn't use the word, okay, shall not register the transfer, etc. Shares are not there. From where the share capital will come? That is a company limited not by share capital but by a guarantee. In that case, the company, the members will have interest but not the shares. Read subsection 1 once. So till you answer properly, I can't go to the next one. So please properly read subsection number 1. Yes. Yes, 1 second. Share certificate. Share certificate is a document showing document showing title. It's not a document of title. Since you asked the question, I am telling you that answer. It's a document showing title. It's not a document of title. Okay. Or difference you know? That you should ask then. You should not ask that question then. Then what is document of title and document showing a title? Document showing a title means, document of title I will tell you first. Document of title means document itself is valuable. You can transfer a document itself. Currency note is a document of title. Currency note is a document of title. This is not the acknowledgement of my ownership. This itself is my ownership. Means I can directly transfer currency note. Listening? Yes, sir. Check. Document of title, not document showing title. Document showing title means this document show that I am the owner, but this cannot be transferred. Share transfer deed is required. Share certificate can't be transferred. What cannot be transferred? Sir, use your common sense and tell me, who will buy the share? Transferor or transferee? Who will sell? Huh? As a common sense person, when a person trying to sell the shares, first what you will ask? What is the proof that? Then what I have to provide? Certificate I will buy. That's a document showing title. Showing a title that I am the owner. Share certificate is, can I transfer share certificate? Share certificate is a proof that I am the owner of these shares. You can't sell share certificate. Listening or not? Yes, so tell me, share certificate is a document? It is not the document? It is not a document of title. It is a document showing the title. Listening everyone in the class? Yes, sir. Listening? Yes, sir. That's all. Sir, okay. Leave off. First one, tell me. Who are the two persons involved in the transaction? Who transfer? Who sell? To whom? What they should execute? What they should execute? SH4, called as what? Send it to whom? For what purpose? Who should send? Either transferor or transferee. Signing should be done by transferor or transferee, any of them. Both of them. Read properly. Execution must be done by both. Sending may be done by anyone. I gave you 3 chances. 3 chances, so you are not reading it properly. At least did you read now properly? Executed by whom? Signed, dated and executed by dash. Both transferor and transferee. Sent to the company either by transferor or transferee. There is a lot of difference between both of them. Listening? Yes, sir. Shall I ask a question now? Yes, sir. Not question. I will explain one concept. Listen. I am the transferor. You are the transferee. Everyone assume like this. I am a transferor. You are a transferee. Listen what happened. I know how to forge your signature. Forgery means what? Imitating the signature of a person. What is it? Imitating the signature of a person is called as what? Forgery. Forgery means imitating the signature. As it is, if you imitate, we call it as a forgery. Do you know this festival, Vinayak Chavati? Yes, Vinayak Chavati will be done yes, at the time. Mud-made Vinayak idols will be there, na? Yes, those things what they maintain are called as a forgings. As it is, it will give a print. Molds will be there, na? Yes, those are called as a forged molds. Means it will already have a shape. Just you need to put the mud in that. Immediately it will generate a forged copy. Those are called as forged molds. Forgery means as it is called as a forgery. Listening? Yes, sir. But in law language, forgery has a negative interpretation, not positive. Now listen, what happens? There are case laws on forgery. That's called as a forged transfer. We will see at the end of this chapter. But first listen to the concept. I am a transferor. You are a transferee. Listening? Yes, sir. Now listen. Who can send STD to the company? Who can send STD to the company? Transferor or transferee? Anyone? Anyone. That means transferor also can send or not? Yes, sir. Who am I? Transferor. Who are you? Transferee. Okay, listen now. What happens is, in one exam question was tested like this. I am the transferor, you are the transferee. What happens is, transferor has taken a share transfer deed. Transferor has taken a stamp paper. Listening? Yes, sir. transferor has taken his own share certificate. Both of them he kept aside. He greatly forged the signatures of transferee. Signatures of transferee. Two signatures he forged. Transferee's signature on the stamp paper as if he is accepting for the transfer. Yes, sir. And I also signed on his check leaves. Common sense here. Yes, sir. At least dirty work you should do properly. Okay. Tell me, he is a transfer or a transferee? You are transfer or a transferee? You should pay money or receive money? Then you should sign a check. I signed on that. Yes, sir. I stolen one check leaf. I have signed on that with your signature. I only drafted one share transfer deed. Your signature I forged also on the document. Yes, sir. And my shares are partly paid. That's why I am transferring. When it is a partly paid share, what will be the danger for me? Sir, there is a company, went on a public issue. Yes, sir. Issue price is 2,500. Application ki 200 they collected. Yes, sir. Balance how much is there? 2,300 is still there. Yes, sir. Listening. Yes, sir. But I am unable to pay. Immediately what I have done, since it is a partly paid share, I wanted to transfer in someone's name. No one will take. Therefore, I forged the signatures of. First, tell the entire story properly. Who am I? Transferor. Who are you? Transferee. Now, who is signing on the document? Transferor or transferee? Both are. Transferor signed the signatures of both transferor as well as transferee. Listening? Yes, sir. And the shares are partly paid or fully paid? And sent that STD. Who sent? Transferor. How transferee will send? Transferee can't send now. Yes, why? He even don't know that he is transferring. So transferor sent it. To whom? For what? Once registration is done, who is gone? Transferee gone, because you are liable to pay 2,300 rupees on each share. For what? You even don't know that you bought. Yes, sir. Do you know what will happen in companies? Forged transfers used to come once upon a time. Okay, even till today it is there in private companies and unlisted companies. Yes, it will go. Listening? Yes, sir. Company will think that signatures are genuine. They will register the shares in the name of a transferee. Yes, sir. He will come to know after 3 months or 4 months or when the call money was called. Then he will look into that issue and he will tell, array, when it happened. But by the time, reasonable time given by Limitation Act will be completed. For the 90 days period since you are silent, estoppel contract will start getting executed. Silence taken as an acceptance, you will become a member of the company. Do you understand the problem or not? Yes, therefore, law inserted one amendment provision to that. They said that if all the conditions are satisfied, what conditions? I will tell you. Shares are partly paid. Share transfer deed is executed by both. Sent to the company by the transferor. What are the 3 conditions? Shares are share transfer deed is executed by both transferor and transferee. Forgery law, you will not know who signed it. Prima facie, signatures are matching. Number 3. And sent to the company for registration by whom? Now who will register? Will not do. First thing the company has to do is send a intimation to the transferee. Send a intimation to the transferee. Babu, transferee, we received one straight transfer deed not from you but from another person. He is telling that you signed on share transfer deed containing partly paid shares. Is this really you who signed on this? Then he will know, na? Yes, then he will tell, when I signed, I didn't sign, cancel that. They will cancel. Yes, I only signed and partly paid shares. They will execute it. That means with whose permission they will do all these things? That's how the amendment has come now. Everyone understood the concept clearly? Where this amendment is, everyone, please read subsection 3 first. Who should give a reply for intimation? Within 2 weeks. Within how many weeks? 2 weeks. Please read subsection 3 first. Hello, have you read subsection 3? First, not just reading, understood or not, everyone? Which subsection we completed now? 3. What are the 2 subsections we completed? 1 and 3. Understood, everyone? Now read. Now listen. Now the question arises. We are reading only transfer. We are reading transfer and transmission. Only transfer and transmission. Sorry, listen now. Some confusion will be there, so please listen carefully. Attention please everyone, listen. Transfer is a voluntary shifting of shares from one person to another. Transmission is by operation of law. Operation of law means involuntary. Death, insolvency, like that happened. For example, tell me, how many parties are always involved in a transaction? Answer. Need not be if it is transmission, because one person is already died. So tell me, A is the father, B is the son, A died, what will happen? Arey, what's wrong with you? Who is father? Who is the son? A died. What will happen? Shares will be transmitted in the name of whom? Answer. Now tell me, shares will be transmitted into whose name? It can't happen unless and until you inform the company. Say for example, A died. Company head office alarm. Your shareholder died. How would I know here if the A died somewhere in Hyderabad? My company register office is in Delhi. Shareholder in Hyderabad died. How would I know? Yes, listening. Yes, sir. In the records of company, whose name will be there? A. But A is really there? No. Who should intimate? B. That person who is intimating that death is called as person intimating the transmission. Everyone, repeat. Very bad. Start from the beginning. What it is? Person intimating transmission. In his name, shares will be transmitted. Shares will be transmitted. COVID virus came. You need to do anything to get attracted. You need to go to the nearest place. If a person is affected by COVID, if you go in contact with him, automatically it will get transmitted. Virus is a transmission. Understand, it is not transfer, it is a transmission. It will automatically happen. You need not do anything. Death also like that. Once death happen, you need not do anything. Automatically company will transmit the shares in your name. SH4, all these things do not apply. That's what he wanted to tell. Listening or not? Yes, sir. But what is your work to do? Not your work, that person's work, B's work. What is the B's work? Intimate about the death. Intimate about the death of whom? A. To whom? Company. That's all. Automatically the shares will get transmitted. Transmitted. To whom? Who is B? Ade, if son, two horns are, legal heir, I will not call legal heir, I call them nominee. I call them. But how company will know that B is a nominee? Section 72. You are not in this world. Section 72. That is the concept. Who will nominate? The holder will nominate one name. That person only should intimate. So that person died first. After writing nomination, he gone. Then you change the nomination once again. Write another nominee. Sir, nominees are not there, sir. I didn't write any nomination. In that case, legal representatives can execute the transmission. Clear, everyone in the class? Yes, sir. What are the two types of shifting of shares? Number one, by way of transfer, by way of transmission. Which is voluntary? Transfer. Which is signed and transferred? Transfer. Which is automatic? Which is by operation of law? Two parties will be therein. Only one party will be therein. That's all. In transmission, the person who is telling about the death, his name is person intimating transmission. Listening? Yes, sir. Please read subsection number 2. Nothing in subsection 1 shall prejudice the power of company to register on receipt of intimation of transmission of any right in securities by operation of law from any person to whom such right has been transmitted. Please read. Two important words are required here. Two important words. Not two, three. Number one. No. Nothing in subsection 1. Adida important. SH4, two parties, share transfer deed, STD, stamp paper, dated, executed, signed, nothing will apply. You intimate about death, it is the company's duty to transmit the shares. Listening? Yes, sir. Okay. Read now. Now I want every one of you to read subsection 2 one last time. Start. Nothing in subsection 1 shall prejudice. Prejudice means damage. Nothing in subsection 1 shall damage means subsection 1 will not damage the power of company. That means company has a power to register the transmission. In whose name? In the name of any person in whose name the right has been transmitted. Generally, who is this person? Nominee or legal representative, legal aids. First, everyone tell me, understood up to here clearly? Yes, sir. Can we go to the next one? Yes, sir. I will answer this with common sense, nothing great. And moreover, subsection 3, everyone understood? Yes, sir. Tell me subsection 3 summary. Don't see. Who executed the share transfer deed? Actually, it is executed by both transfer and transferee. Sir, if I have my signature, for example, I gave my signature on a document. I gave a signature on my document. Another person came. He also executed the same signature. He also executed. Company will see whether signatures are tallying or not. That's all. Even in bank, what manager will do? Whenever you send a check, it will go to manager. Manager will open the computer system and he will see whether the signatures are tallying or not. Signatures are tallying. What they will do? Transfer money from one account to another account. Game over. Yes, sir. My mistake is not there. Yeah. Sir, you might have seen liabilities of the paying banker, liabilities of the collecting banker. Yes, sir. Negotiable instruments. liabilities of the paying banker, duties of the paying banker, liability of the collecting banker, duties of the collecting banker. When the bank check is presented for honor, what are the reasonable checks bank has to do? When it is sent for presentment, when it is sent for collection, when it is sent for honor. So many concepts are there now in that what you learned. Same concept. It is a responsibility of the banker only to check and tally the signatures of the candidates.
Yes, sir.
Even company, what it will check? Whether the signatures are tallying or not, I will check. Tallying, I will execute the transaction.
Yes, sir.
Now tell me, but amendment has not provided for direct execution. You tell me, I will listen. Who sent STD? Huh? Very good. To whom?
Company.
For what?
Registration.
Registration will be, and shares are which shares? Which share? Now tell me, what company has to do first? Intimation. Intimation to whom? And ask him to respond within 2 weeks. If he don't have any objection, it will transfer, or else it will not transfer. If you don't reply within 2 weeks, it is presumed that you don't have any objection to the transfer. Listening everyone in the class? Yes, subsection 3 we completed or not? Yes. Now question for you. Don't get irritated that I am asking too many questions for you to answer, because chapter is very easy from now. Please answer to the point. We'll go to the next subsection. First tell me, transmission law, how many persons will be there? Who is that? Person intimating the transmission. That means in his name the shares will be registered. A. Died. Shares transmitted to B. Listening?
Yes, sir.
B. Can he transfer to others? Listen. Listen again. That's why I asked you to listen. A. Died. Shares transmitted to B. B wanted to sell the shares and get money. Can or cannot? Answer. Can, as if he is the real holder of the shares. He can do that. Subsection 5. Subsection number 5. Hello, did you complete everyone?
Yes, sir.
Hello, everyone completed?
Yes, sir.
What you read? Ate, what? Really? Subsection 5 you read? I thought Bhagavad Gita episode number 10. Subsection 5A, what you read? Can the transmitted person being the registered owner now, can he transfer shares to some other person?
Yes.
As if he is the holder. That means he will get all the rights of original holder.
Yes, sir.
Next. Please come to 6 and 7. Where any default is made in complying with the provisions of 1 to 5, then every officer and company will be liable to a penalty of how much? 50,000 rupees. Okay. Next. If intentionally, listen, just now I told you about forgery case. Yes, who made a forgery? Forgery is a fraud or not a fraud? Fraud. With a fraud intention, if you do anything, then liability will be under section number 447. What is 447? Fraud. It is there in your auditing. Hello, it is there in your auditing. Explain what is a fraud. Chachindi gorre. Tell me, what is a fraud? What you do is a fraud. Huh? I think I told, hey, I forgot. Scam, I told you. Which chapter? Prospectus. Section number? I think you have written the notes also. Fraud in relation to the affairs of a company or a body corporate includes an act, omission, concealment of fact or abuse of any position by any person or by any other person with a connivance with an intention to defraud or to gain undue advantage from or to injure the interests of the creditors, shareholders or any other person, whether there may be a wrongful gain or a wrongful loss. Explanation below section number 447. Have you completed or not? Yes, same. That 447 will get attracted even here. Explain what is a fraud. Hey, fraud. Explain what is a fraud. Fraud in relation to the affairs of a company or a body corporate includes an act, omission, concealment of fact, abuse of position by any person or by any other person with a connivance, with an intent to defraud or to gain undue advantage or to injure the interests of the creditors, shareholders or any other person, whether there may be a wrongful gain or a wrongful loss. This is what defined in section number 447. Okay. Same penalty will get attracted also here. When if you try to do the defraud. 6 or 7, tick that. Okay. Tell me what are all the sections. What is the only subsection that was left out? What is the only subsection that was left out? Keep that in hold. I will tell you why. Subsection 4 you keep in hold. Come to section number 58. Come to section number 58. Okay? 58. Sir, exactly 30 minutes chapter will be, this area transmission will be completed. Once completed, I will leave you. Because last area, another 1.5 to 2 hours discussion will be there. Tomorrow I will put it. Anyway, if I start today, it will not be over. 90% I promise that 90% surely we will complete. With this, we will complete every section except 6 sections in this particular topic. How many? 6. I will tell the names. 48, 46, 46 certificate of shares. 48. Next, 49 completed, 50 completed, 51 completed, 52 completed, 53 completed, 54 completed, 55 we have to deal. 56, 57, 58, 59 we will read now. 60, 61 we didn't complete. 62 completed, 63 completed, 64 we have to read. 65 not there in your syllabus. 65 the NA not applicable. 65. 66 we completed, 67 we completed, 68 we completed, 69 we completed, 70 also we completed. With that 70 chapter will be over. Nomination not applicable for exams, I told you I think. 72 section also put the heading NA. Nomination concept also not applicable. 70? Separate chapter, debentures. We are reading share capital, not debentures. 71 is a debentures. Debenture is a separate chapter. Share capital, it will end. 70 it will close. So technically we are having only 6 sections. Listening everyone? Yes, max 2 hours time we will spend to complete this chapter. Once completed, we will go to the next chapter in this particular area. So before going into that, let us complete properly transmission and take the leave for today. Clear? Yes, half an hour it will take maximum to complete remaining. That too after repetitions. Very easy. Listen carefully. Shall we start? Yes, sir. Let me first explain what is this concept of refusal of registration and appeal against refusal. First listen. If you remember the concept of public and private companies, what is a private company? Private company means a company which is having minimum paid up share capital, but by its articles, it restricts the transfer of shares, limits total number of members to 200, and prohibit public subscription. In that, what is the first one? Restrict the at the problem. That is the point here. You sent for registration of transfer, private companies refusing to register that. You are not liking the refusal, you are going for tribunal. That's what we are going to learn. Which company? Very bad, everyone. Which company? I said it depends on you how you respond. Easy section, dates you need to remember. Tell me now. Which company we are talking about? In private company, transferor has transferred. Shares to whom? That transferor or transferee will send the STD to whom? For what? Company registering or not registering? Which company? We are asking. Why are private company? Why you rejected? It has to give the reasons for refusal or not? Within 30 days, it has to give the reasons for refusal. Company, if it accept, no problem. If it rejects, within 30 days from the date of receipt of that STD, date of due dates are important. Date of from whom? Transferor or transferee. Small point once again. Who will send? Very good. To whom? What they send? STD. For what? Registration of what? Transfer. Sometimes transmission. Death time, what will be sent? Transmission. Company registered the transfer. Company didn't register the transfer. I will be happier, aggrieved. Company should just refuse. It should give reasons for refusal. Within how many days? It should give the registration or it should tell why you are rejecting it. Then within next 30 days, I can go for an appeal. I can go for how that appeal will be is the subject matter of discussion in this section. Sir, only private company or public company also covered by the section. Public company la shares are restricted to be transferred, freely transferable. In that cases also sometimes they may restrict certain people like rival directors, rival company directors. At that times they will even restrict them. At that time how to go for appeal is the subject matter of discussion in these two sections. Shall we start?
Yes, sir.
First read 58 section. Start. If a private company limited by shares refuses, whether in pursuance of power of the company under its articles or otherwise, to register the transfer of or transmission by operation law of the right to any securities or interest of any member in a company, it shall within a period of 30 days from the date on which instrument of transfer or intimation of such transmission as the case may be was delivered to the company, send a notice of refusal to the transferor and the transferee or to person giving intimation of such transmission as the case may be, giving reasons for such refusal. If you remove all the scrap and unnecessary content, simple concept is, who sent it? To whom? For what? Within how many days? Company has to give a reply. If it accepts, over. If it do not accept, it should give the reasons for refusal. Who? This is what he wanted to tell in the first subsection. Everyone understood? Yes, sir. Okay. Please read subsection 2. Without prejudice to subsection 1, the securities or other interest of any member in a public company shall be freely transferable, provided that any contract arrangement between two or more persons in respect of transfer of securities shall be enforceable as a contract. Simply, transfer of shares is nothing but a contract. Because contract la how many parties are involved? Answer. One will be offeror, another one will be offeree. Here one is a transferor, another one is a transferee. Transfer is a transaction which is a contract under Contract Act. Simply you want to tell it should have all essentials of contract. Consent, approval, consideration, everything should be there.
Yes, sir.
Next. Please read. 1 minute time I will give. Read subsection 1, subsection 2. Fast. 1 minute time exactly. Fastly complete. Okay? Completed?
Yes, sir.
Okay. Now listen. We have now completed subsection 1 and 2. Correct?
Yes, sir.
See the screen once. This chart is not yet completed. I told you already. Only some part of the chart only I have completed. See here. Now listen. Please answer. On D0 what we have done? Sale happened. Between whom and whom? What is executed and delivered? What is executed? SHF4 is executed. Correct? Now listen. We sent it to whom? Within how many days? We delivered it to company. Delivery of the STD is made to the company immediately. 60th day na? They gave us 60 days. I transferred on 60th day. I am a typical Indian. I do all things on due dates. If you give, seriously I am telling, September month is the tax month totally, tax audit time. September 30th we will file at least 40-45 clients returns. Then what we will do in the month of July, August, September, this is what we do. At the time we have to do work in office, happily we will sit in revolving chair and take classes. Client we will tell that we are working on it. He will come in the month of September again. At the time peak 30th September we will complete. So typically like any other Indian I also have done. 60th day last and 60th day we delivered. Now company will take how many days time?
30 days.
How many days time?
30 days.
Now company will take 30 days time. How many days time? 30 days. Two situations, please. Two situations will happen. On D90 means what? D90 means what? 30 days. Last date company also submitted me. Notice from company that transfer is refused. Transfer is refused. Depending on that, they will also give the reasons. Listening or not?
Yes, sir.
Now, listen carefully. Once this is done, from this date, within next coming 30 days. How many days? Next coming 30 days. Now that was amended and made as 60 days. Okay? This is last date for filing an appeal. To whom? NCLT. File an appeal to the NCLT. Don't write anything, see here. First you confirm me. Subsection 1 over. Yes, 2, yes, 3. 3, we completed 3. Now I completed. See. 1 second. Who is the transferor? Person who is selling or buying? Selling. Who is the transferee? Buying. Now, if the company refuses the transfer, who is happy, who is unhappy? If no, one person will be guaranteed unhappy. Another person may be happy, may be unhappy depending on the circumstances. But one person is definitely unhappy. Who is that one person who is definitely unhappy? Sir, God has given us. Why you don't use in many cases? Transferor is a seller, buyer. He received share, he transferred the shares are not a transferred. Transferred or not a transferred. Registration refused means shares are transferred or not at not at. Money received or not received? Money received. Money received, but the shares are not transferred. But understand the transfer situation now. Money received, money paid or not yet paid? Paid. Transfer happened or not happened? Now you tell me who is most unlucky fellow? Transferee. That's why transferee may prefer an appeal. Not transferor. Who is the most affected party? Transferee is the most affected party. Listening. If company don't do registration, there will be definitely one most affected party. Who is that most affected party? Transferee, not the transferor. Listening? Continue. The transferee may appeal to the tribunal within a period of 30 days from the date of receipt of notice. Okay? Sir, you write 60 days. Depends. See here. One see here. This is both 30 and 60. Once upon a time 30. They changed it to 60 in another case. What is that case also I will tell you. Generally it is how many days? 30 days. You will prefer an appeal to whom? Tribunal. Within how many days? 30 days. Now listen. Same chart. Everything is same. Listen. Sir, I am preferring an appeal within how many days? 30 days from? Very, very bad. Tell me, I am preferring an appeal to whom? Within 30 days from what date? 30 days from the receipt of the notice of refusal. From whom? Within how many days company has to give me? Then from that another 30 days time I was given. Yes, say, company didn't even intimate me about refusal. I have been waiting, they are not giving. Listening? Yes, sir. After 30 days also, if the company don't give intimation, law said that within 60 days from the what date? Date of delivery of IoT to the company. From there how many days? 60 days. You can file an appeal. That's what he wanted to discuss here. Please read it. Completed? Huh? Doubt? Chart, I will show that. One, have you read the provision clearly now? Sir, summarize only the time limits and tell me. Tell me. You transfer the shares on which date? You sold on which date? Submitted to company within? How many days, sir? From there, company should take how much time? Should tell whether it has accepted or refused. Accepted, well and good. If it doesn't accept, what it should give? Notice with reasons. Notice with? Then from there I can go for appeal. Within how many days? One part over. Everyone understood? Company didn't give any intimation to me. That's a rogue force. Company didn't give any kind of intimation to me. I waited for 30 days. It didn't give. 31st day onwards, you need not wait. Within 60 days from the date of delivery of that particular IoT, you can go for a appeal. Appeal to whom again? NCLT only. You can go for an appeal. Everyone understood the concept clearly? Sir, till now we read for private company or public company? Answer. Same concept applicable also for public company with the change in dates. I will tell you what are the changes. If it is public company, this 30 is same. Listening? This 30 change to 60. This 60 change to 90. Answer over. That is what in subsection 4. Read it. Starting words they have clearly given what it is. If a public company first point, everyone tell me, have you read subsection 4? Yes, have you read subsection 4?
Yes, sir.
Completed?
Yes, sir.
Very good. Next. Did you find all the points what I said there?
Yes, sir.
Tell me, fastly tell the due date. Company should intimate within? 30 days. From there I can make appeal within? 60 days. Next. Company don't give intimation. Within how many days? 90 days. Within how many days? 90 days. You can directly prefer an appeal to the NCLT. That's the answer. Everyone understood? Now, lastly, you tell me, matter goes to whom? Whether you intimated or not intimated, matter will go to whom? Now, see here. Matter goes to NCLT. Now, when it goes to NCLT, there are only two answers. One is a favor, another one is a against. Favor, against. Against is also called as a dismissal of appeal. Against is also called as a dismissal of appeal. If it comes in favor, NCLT will order the company to register within a period of 10 days and also pay compensation for the delay cost. If it comes against, transfer will not be made. Over. Please read subsection number 5. The tribunal, while dealing with an appeal under subsection 3 and 4, may, after hearing the parties, may either dismiss the appeal. This is first one. Either it can dismiss or by order Direct transfer or transmission shall be registered by the company within a period of how many days, sir? 10 days. And also rectify the register and pay damages. If any person contravene, this is the penalty. Penalty anyway, I will give a separate chart. Did you read? Now, main section, the big sections are completed. Two bacha sections are pending for us to complete today's discussion on share capital chapter. As I promise you, another 15 minutes only will complete this. But before going into that, please answer one question from my side. Answer. In which company refusal is common? In which company it is uncommon? Therefore, timing was also given on a lengthy side. If it is a private company, it is a 30, 60. But here, 30, 90. Like that, the term limits have been given. Listening? This is one issue. Next, very important thing. Why it has to refuse? Na? I got a doubt. Why it has to refuse? Why private company has to refuse? Listen, private company, we entertain public. We entertain public to come inside the private company. Therefore, whenever you try to transfer the shares in the name of a stranger or a general public who is not suited for our private company, that private company can refuse it or not? Yes, sir. Everyone? Yes, sir. Now listen, he is there. Your name? Mohit. Mohit is an outsider. Is a? Outsider. Now, he is leaving the company. Suraj is leaving. He wanted to transfer his shares. He wanted to transfer in the name of whom? Mohit. Now, Mohit is an outsider who is not known to any of the persons in the private company. Listening? Yes, sir. For Suraj, I am his own brother. Say for example. Now, I can become member of the private company because I am a known person to him. Yes, sir. He is an unknown person. Clear, everyone? Yes, sir. Now, what happens is, this fellow Mohit, what he will do is, he will write my name and he will send the documents to the company. Application will be made by whom? Mohit. But in whose name he will send? My Aadhaar card, my details, everything he will send. But at the back end, who will be there and doing all those things, sir? Mohit. This concept is called as a personation. Personation means doing the things in the name of another person. Typically in our normal language we call it binami. Yes, sir. Section number 57. Nothing will be there in 57. Just you need to remember punishment. That's why I am not giving importance to that. Already punishments, one chart is prepared. I will just share it. See here. Whenever you do personation, can you please explain what is personation? Pretending like another. Listening? If any person deceitfully, so deceit means what? Genuine or cheating, with an intention to cheat, personates as an owner of a security or an interest in a company or share warrant, etc. Okay, sir, lastly I want only one thing. What is the punishment? Just read it. He shall be punishable with imprisonment for a term which shall not be less than 1 year, but which may extend up to 3 years. So, just like that you can write here, minimum imprisonment will be 1 year. Maximum imprisonment will be 3 years. And with the fine, which shall not be less than 1 lakh, but which may extend to 5 lakh. Means minimum fine is 1 lakh, maximum fine is 5 lakhs. That's all. So tell me, what is the punishment for personation? Arey, just a punishment also you can't answer. What is the punishment for personation? Imprisonment minimum 1 year, maximum 3 years. Fine minimum, maximum. That's all answer over. For personation, that's a punishment given. Okay. What is the last section to complete? 56 we completed, 57 we completed, 58 we completed, 59. Okay. First, let me explain 59. After that, you read. Listen carefully first. Easy section with a small top point. Once you understand that, it will be easy. See here. I am not a member of a company, but my name is there in the register of members in the company. I will be happier, unhappier. I will be unhappy if it is a partly paid share because I have to pay the balance. Listening?
Yes, sir.
So don't get excited always. Your name is there in the register means you are also in an obligatory situation.
Yes,
Therefore, listen. I sold my shares. I sold my transfer is registered. But my name is still appearing in the register of members. I am a transferor. I am a transferor. I will sell or buy. I sold. You bought. You are a transferee. I am a transferor. STD sent. Registration also done. Once registration is done, in the register whose name should be there? Your name should be there. My name should be removed. Correct?
Yes, sir.
But still my name is only there. Or your name is not getting entered. Either I can make appeal or you can make appeal now.
Yes, sir.
Sir, we are making appeal against refusal to register, against non-entering the name in the register. Either non-entering of name or wrong entry in the register. Or delay in adding the name or delay in removal of the name. Anything happens, you can make an appeal to the tribunal. Same. Tribunal will give an opportunity of being heard to the parties and it will hear both the parties. It may either dismiss an appeal or it will order the company to change the register and rectify the names within a period of 10 days. Answer over. That's all. That's the range of that section. Let us read together. Let's read together. You can understand more easily. Start. Please don't waste time. Start. If the name of any person is without a sufficient cause entered in the register of members of the company. Stop there. First, correct entry, wrong entry. If the name of any person is entered, it is a removal, wrong removal or wrong entry. First one is a wrong entry. Next, or having been entered into the register is without sufficient cause omitted therefrom. Stop there. This is wrong entry, wrong omission. What is the first one?
Wrong entry.
Everyone.
Wrong entry.
Second one, wrong omission. Or next one, or if a default is made, who made a mistake? Company. Or unnecessary delay takes place in entering the name in the register, the fact of any person having become ceased or having become or ceased to be a member, the person aggrieved or any other member of the company may appeal to the tribunal. So simply, see here. If you want, you can write here. First one is a wrong entry in register. Second one is a wrong omission in the register. Third one is a default committed by company. Fourth one is delay in entering. Delay in entering about. Delay in entering about entry or delay in omission about Caesar. 5 things are there. In your simple English language, if you have to explain, I am not a member, my name is entered. I am a member, my name is omitted. I am a member, but some other's name they are writing, or my name is written in a wrong way. Defaults are committed. Listening. Number 4, there is a delay in entering about my entry. There is a delay in omitting about my exit. Listening or not? In all these cases, what you can do? In all these cases, what we can do? Appeal to whom? NCLT. Okay. Next. This is applicable not only for the Indian members, this is also applicable for the foreign members. That means shareholders of Indian company but who are residing in a foreign country. They also can make. Sir, okay. Mainly come to subsection 2. Mainly come to subsection 2. Read the subsection 2 and tell whether we have already completed that or not. Had we already completed that or not? Yes, write down there, sir. Same as section 58. So subsection 3, write down, omitted. Recently that was also omitted. Last one, subsection number 4. Please read. Where? 1 second. Answer me. What are the 5 kinds of situations which attract section number 59? Number 1. 1 second. What is wrongly entered? Name of a person has wrongly entered into the register, or name of a person has been wrongly omitted from the register. Next. Default is made in adding or omitting. Next one. There is a delay in entering about my entry as a member. Listening? Next one. Delay in omitting my name about my exit. I exited from the company, even though my name is still there. They are making delay in omitting that. In all these cases, you can make an appeal to whom? Once you make an appeal, what NCLT will do? Either accept or dismiss. If it accept, it will give how many days time for the company? 10 days to rectify the register accordingly. Everyone understood the concept clearly? Last subsection before we close the today's class. Please read subsection number 4. Start. Where the transfer of securities is in contravention of any provisions of, see the screen, SCRA or SEBI or Companies Act 2013 or any other law. Now read. Transfer of securities is made in compliance or in contravention? Everyone tell all the names. What is the contravention? Contravention of which act? SCRA, SEBI, Companies Act or any other relevant law. Okay, it contravene. Then what will happen? The tribunal may, on an application made by depository or company or depository participant or holder, anyone, direct any company or depository to set right the contravention and rectify its register. Simply he is talking about what? Electronic transfer. Common sense should be applied. Stock exchanges, depositories, depository participants, all these people will be involved when there is a physical transfer or electronic transfer. Any problem in the e-transfers are not governed by this section, should be governed by the respective acts. Listening, everyone? Yes, sir. That's all. With this is also completed. Our set of all the sections have been completed. In section number 56, subsection 4 is there? Yes, right there. Refer section 46. We will read it tomorrow. Share certificate. Which certificate? Yes. See here. What is the word used here? Certificates. There we will read. Section 46, we will link it. Okay, you will understand in a better way if you read along with it. Okay. With this, we have completed more than 90% of the share capital chapter as promised to you. Tomorrow's session will complete 2 hours. Max 2 hours. Tomorrow's session, max 2 hours we will take. We will complete share capital chapter. Once the share capital chapter is completed, then we will go into another small chapters and we will complete. First one we start with dividends. What is the chapter we start? Dividends is a chapter we will start. It takes around 3 hours to complete dividends chapter. 3.5 hours. Once completed, I will start with deposits. Once completed, I will start with charges, debentures, small. 2 hours concepts are there. First, I will complete all those small areas. Listening? So that we will take one big area again. Substantial syllabus will be completed along with it. First point, everyone tell me, have we all understood?
Yes, sir.
So thank you very much. We meet again in the tomorrow. Chart, you take a photo. One second, I will make it full screen. I will make it full screen. Wait a minute.